Welcome to Disqualified Dads. I am your host, Farouk, father who was disqualified March 16th, 2022. 2.5 years nearly now, haven't seen my kids. Hence this channel. We're trying to put awareness and knowledge around the family court system on this channel, Disqualified Dads. Like, subscribe, follow and share. Now, today's video, this is a quick video that I am going to be covering some elements around CAFCASS and the new laws that CAFCASS now seem to have in place. On a lot of the fathers groups, there's a lot of chatter around this ultimately. So I thought, let's get an expert opinion. Mr. Ryan is going to come on and clarify exactly what this means for parents that are in the family court, especially fathers, especially those fathers that have been accused of domestic abuse, DV, sexual allegations and whatnot. So let's not mess about. Let's get Mr. Ryan on. Mr. Ryan, welcome back.
Good afternoon, sir. How are you doing?
I'm good. I'm good. It looks like you're working, Mr. Ryan, on the weekend. Would that be correct?
It's one of those rare occasions where I'm actually sat at my desk doing something. Yes.
Wow.
Yes. So you've interrupted my flow while I'm trying to plow through some casework. But yes, because obviously the latest little Cafcass drop is interesting and is causing a bit of a stir. So I thought we may as well have a chat about it.
Absolutely, absolutely. So before we have a chat about it, Mr. Ryan, let me bring up what's going around in groups, the sort of documents that are going around in these groups. Let me enlarge that. Right, here we go. So CAFCASS published a new domestic abuse practice policy, blah, 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 blah. I don't know if you've gone through all this, Mr. Ryan, but let me just read it out. Okay, so today Cafcass has published a new domestic abuse practice policy. The policy sets out the practice requirements that Cafcass Family Court advises FCAs and children's guardians must follow in protecting child and adult victims of domestic abuse when they advise the courts about the welfare of the child and the child's best interest. Now, this is where it starts getting a bit hairy. Hold on, how do you enlarge all this? Right, that's as big as I can go right now. That'll do. Let's try again. No, that's it. Is it the wrong button? Here we go. Right, let me just quickly read this out, Mr. Ryan, so we're all on the same page with the viewers. The new policy makes clear that FCAs and the children's guardians will no longer use language such as claims or alleges in reports to court using instead of the words of children and adults who are victims of domestic abuse. It is for the court to determine the facts. The starting point for recommendations about a child spending time with a... Okay, so before we go on to the next point, Mr. Ryan, can you just cover this? Yeah, tackle that first point to say we're not going to use it.
I will say at the outset, obviously this document dropped back end, or what was it, 10th of October, something like that.
Yeah, yesterday. I think
the document dropped on the 10th, I think it was, or maybe the 11th. And in principle, I have no issue with it. I have no issue with the fact that Cafcass has updated its domestic abuse practice policy. It was long overdue. Where the issue lies is in the consequences of it, and that's probably where we're going to dwell today. But if we start at this first paragraph, what we're looking at now is the statement that came out that's from the chief exec, whose name I've just forgotten, but from the chief exec of Cafcass in support of the policy which came behind it. So this first paragraph here, where the Cafcass is saying that they're no longer going to use language such as claims or alleges. I have to say I'm quite delighted by that. One of my criticisms, and yes, I have been criticizing Cafcass over the years, but one of my criticisms of Cafcass is that some of their officers do take it upon themselves to prejudge the case, in the nature and in the format in which they write their reports. And so, they do use claims, so-and-so claims, father claims, father alleges, mother alleges. And Cafcass have now realized that actually that's not their role. Because by using phrases such as he or she claims, he or she alleges, you are prejudging because you're already saying, and I don't believe. Okay. Or indeed, it must be true because he said it or she said it. So removing themselves from that role in order that they just focus on reporting the facts, I think is a very positive thing. The fact that now they're going to use the words of the children and of the adults who are the victims is a good thing in terms of the policy, Where it will stray, not in the case of children, but where it will stray is it potentially presents the opportunity for a gloriously dramatic narrative from one party, describing their allegations against the other, and CAFCASS are now essentially tied themselves down to reporting it word for word. That possibly gives me some concern, because that possibly presents then some very melodramatic script that's being read in court. The other issue in terms of children, the words of children, they're going to report the words of children. Well, that's great. But they have no idea, because I don't believe that they are trained, but the CAFCASS officer has no idea if those children have been manipulated, coached, alienated in order to say what they are currently saying. Because one of my fundamental issues with CAFCASS is I don't believe that they are suitably au fait with the principles of parental alienation.
Right.
I think they almost ignore it. And certainly, and I'm not jumping the gun any, but in terms of their domestic abuse practice policy, which I've read cover to cover half a dozen times, nowhere does it mention parental alienation as being a form of abuse. In fact, it doesn't mention it at all. That gives me a concern, because that's quite a significant oversight. Anyway, but in terms of that particular paragraph, very positive, the fact that CAFCASS now see their role as being reporting the facts rather than essentially providing an opinion on them.
Okay, so look, if you're saying it like that, where they're going to just report the facts. So let's say one parent, forget mother, father, one parent makes all these allegations to say, I am a victim of domestic abuse. I'm reporting this, this, and this. Hence, the other parent cannot see the child. CAFCASS will report that as fact. There's no one parent is alleging or claiming. It is demonstrated as fact. So when you're saying they're removing themselves from the decision, are they not?
Well, CAFCASS are not. CAFCASS in this new policy, and to be fair, it was also in the old policy, but unfortunately they strayed away from it a little. CAFCASS are now saying that they are not there to prejudge. They are reporting one party's version of the facts. Okay. And they are reporting the other party's version of the facts. That is what they are doing. The issue comes, and we're about to get onto it, but the issue comes, as I say, where obviously, particularly sexual abuse is paraded, because that does have some quite significant implications. We're about to come to that with this paragraph that you've got on the screen now.
Okay, all right. So let's move on to that paragraph. But just so I understand and the viewers understand, and because of the way you've explained it, it's not a bad thing. CAFCASS have been told to just come out of it. You don't make any judgment. You just report the version of events that was presented to you by either party. You have no say in whether it was right or wrong, guilty or not guilty, or I believe mother or father's guilty. That's irrelevant. So that is a good thing. It does sound like a good thing.
That is a good thing, because it means that somebody who is being accused of allegations does not first have to fight for their innocence with CAFCASS before they even get into a courtroom.
Gotcha. Okay, so that's not a bad thing. That makes sense. All right, let's move on to the next paragraph. The starting point for recommendations about a child spending time with a parent who's being investigated by the police for a sexual offence, who has a conviction for a sexual offence, and or who has served a prison sentence for violent sexual offences, is for that child not to spend time with the parent due to significant risk of harm and the risk of further harm to the child victim, as well as the impact on the adult victim of the abuse. Shall I read more, or do you want to wrap that up?
Yeah, no, let's tackle that. Okay, for a start, I have nothing to say on if one party in a matter, be it a dad or a mum, has got historic convictions for sexual abuse, or for sexual assault. Forgive me, but unfortunately, until such times as we understand better what's going on, regardless of who they are, their children should be removed from them. It is as simple as that.
Agreed. Yeah, agreed. I think that makes. I don't think anyone will argue with that.
Yeah. I think that is just as simple as that. If you've already been prejudged by the criminal court, I'm sorry, but that's down to you. Yes. The danger of this particular paragraph, the issue of this that I have with this particular paragraph, as I say, is not the paragraph per se, is not the policy per se. It is the fact that it presents the mother, or indeed the father, it's a two-way street, with the opportunity to rush off to the police, plead sexual assault, sexual violence, sexual abuse, in order to have that individual, have the other party arrested, and then suddenly you are now being investigated by the police, which means CAFCASS are now saying within their policy that almost automatically your contact with your children will be removed.
Right.
And later in the policy, just jumping ahead, but later within the bones of the policy, within the meat and bones of it, it says if the children are in your care at that, your children are living with you at that time, be it partially or fully, and the other party reports the fact that you are currently being investigated by the police, those children will be taken off you.
Yeah, I think the issue with
go on.
Yes, I think so. What this presents is basically, I mean, look, no one is arguing with the fact that the child, if someone has history, convictions, they've got form on this, they shouldn't be around any children, let alone their own. They shouldn't be around any kids. No one is arguing that. We understand that fully. The problem here is because this paragraph is within CAFCASS's new handbook or law or wherever it is mandate. The problem is a bit like the legal aid mandate. You only got legal aid if you were a victim of domestic abuse. Yep. So suddenly, when that mandate came in, the domestic abuse allegations and DV allegations went up to secure legal aid, putting one party in a stronger position by getting them legal aid. Where this is now saying, if one person is labelled with this or being investigated, that will automatically give the other parent the upper hand. So you've now just presented a tool that can be used. We know all the tools and mechanisms that are used against one parent to the other. This is now, unfortunately, just given one parent another tool to use against the other parent to gain the upper hand by securing the children, basically.
You're absolutely right. The practice policy, and I say that I'm sure it wasn't its intention. It's just unfortunately where it is. The practice policy has provided a tool, a recipe for mother or father to put themselves in a very strong position. The practice policy is essentially saying all you need to do is involve the police. It's that you involve the police, and we're going to react to that. You are going to get access to legal aid, which means now you are fighting at no cost to yourself. You are now in the pound seats, and you're not even paying the pound. You are in a fantastic place because, as I say, you've got fully funded legal representation, which means you can roll out barristers and solicitors at the drop of a hat. And your children are now with you because the other party has now essentially been ring-fenced to say, currently, you are deemed to be a threat.
Great. Okay.
And that is a worry. But the problem we have, that is a worry, and I'm worried about the fact that recipe is now available. Unfortunately, that recipe is published in very clear English. It's not. Step 1, go to the police. Step 2, apply for legal aid. Step 3. So it's a little bit worrying. But the problem that CAFCASS have, and I'm going to come to CAFCASS's defence now. The problem that CAFCASS have is they have to create a policy, and if you read the policy, without the colouring, without the colouring that we're applying to it, it is a very straightforward, very clear, very clean policy, and I don't have a great deal of issue with it. I think it's quite sensible in parts. The problem is that anytime you write anything down, there is always an opportunity to flip it. Always, doesn't matter what you write. There is always an opportunity to flip it, and this policy presents an opportunity for one party, or indeed both parties, if they really want to go into war, but for one party to flip it and immediately put CAFCASS on their side because it tells them how to do it. You say police to us, we say we're with you.
Yeah, bloody hell. Okay, we can see where this is headed. Right, let's move on to the next paragraph. Sorry. FCAs and children's guardians are required to provide clear and equivocal and compelling rationales in their reports to the court if they do not adhere to the starting points set out in the policy, and if their assessment and analysis they recommend time with or live with arrangements when domestic abuse is being investigated has been found, is known, or is reported by a children's and adults or something like that.
Yeah, that's fine. So this is where the policy is actually closing down CAFCASS's ability to operate as well, because what it is essentially saying is if you as a CAFCASS officer say, I'm aware that there is a domestic abuse allegation here, I'm aware that the children are involved, But I've seen the children in the care of their father, if he's the guy being accused, or I've seen them in the care of their mother, and I don't see any issue. The children are perfectly okay, which means I am essentially going to go against the policy, and I'm going to say, actually, I'm happy for contact to continue. What this little chunk of narrative is saying here, be prepared to justify that, because your line manager, when you present this report for it to be signed off before you send it to court, your line manager is going to say, hang on a minute, why are you stepping outside the rules? The rules are very clear. They say if there's abuse, there's no contact. You're saying there's abuse, but I still think there should be contact. We, as CAFCASS, are not prepared to take that risk. So you are now going to change your report. So it's removing that opportunity for a CAFCASS officer to have any degree of professional flexibility. And, and to be fair, there are some fantastic CAFCASS officers out there. But it's removing that opportunity to have any professional flexibility to look at a situation and say, I appreciate the issues. I appreciate the allegations. I appreciate there may be police involvement. But in the best interests of these children, I believe contact with both parents should continue in some form or fashion.
But yes, he will be challenged. Ultimately, if he sticks his head above the parapet, goes against the grain and say, professional judgment, this father's okay, this parent is okay, I don't see why she sees contact, he will be challenged by it. He's got an uphill battle now with his line manager. Hence, they are being coerced into falling in line with what the black and white says.
Yep.
Abuse, no contact, send it to the court, and that'll be that.
Yep.
Great. Okay. That's depressing to hear.
It is depressing, yeah. It is depressing.
Right, let's move on to
I'll put my point up in a minute, but go on.
Yes, now go on. What's your point? Shall I carry on?
It was in respect to that. So the issue that gives me is where somebody has, where a party, mother or father, has gone off to the police for argument's sake and played the sexual abuse card. That's always a classic, because at that point the police sort of sit up and look at you and actually pay some attention, which invariably they don't. But so if you play that's the sexual abuse card, and CAFCASS follow their own rules. Their rules now say that's it. The other party cannot see the children. Full stop. Because you and I know, well, you better than most, me over years and years and years, how slow the family court is. That decision to remove those children from any contact with their father. Actually, let's use the instance of a father. So to remove their children with any contact with their father, that situation could actually last for months. And when we then get to court and mother says, well, actually, I kind of made it up, or we discover that she made it up, we discover there's no value to it, there's no substance to it, that's great. And we reconstitute contact. But what is the damage that's been done in that period in between?
It's done. Yeah. I mean, add to that the delays that we have in the court, as you're aware. This could mean like a minimum, I reckon, 1 year potentially without any contact. The mental,
in some cases,
and to be labelled, let's say one parent makes that allegation to get the upper hand. For any parent to be labelled with that, firstly, the psychological and the mental impact of being labelled and looked at like that by the police or anyone, number one. The impact to your professional working life, your personal life. I mean, and effectively, I would presume you'd be removed out the home. If you're being investigated, you will automatically be removed out. You could potentially be homeless. So, let alone the fact that you're not going to see your children is one part of the trauma. But if you combine all the other factors and the traumas, like it's a combined trauma, being homeless, potentially losing your job, being out of pocket and being labelled. If the rumors get out that he's been labelled with this, I'm not being funny, it can be very dangerous for someone just to say that, to destroy not just their children, but regardless of the fact it's an ex, that they may not even survive that year. That's the reality. I mean, as you know.
That's true. Yeah, no, that's true. As I say, the potential impact is, well, the potential impact on the children is lifelong.
Yes.
They may never, that period of time, whether it's 6 months that they're not in their father's, in contact with their father, or 9 months they're not in contact with their father. In a child's life, 6 months is a long time. You know, if we look at a 4-year-old who hasn't seen their children for 6 months, that is a significant percentage of their entire life.
Absolutely.
And you know, children, the paternal bond and indeed the maternal bond are fed by contact. You know, the reason that children build up such a relationship with their father and such a relationship with their mother is because they have daily contact with them, and because the trials and tribulations of life, you know, they are protected from them. You know, the storm, they are protected from the storm by their parents. In this instance, what has happened is one party has decided, well, actually, I'm going to create the storm, and I'm just going to unleash it on dad, using our example. I'm going to unleash it on dad, and I'm going to allow my children to stand and watch that.
It's bad, sad.
It's awkward. Yeah, it's awkward. Anyway,
right, let's move along. Right. This is why we continue to prioritize further improvement in working with child and adult victims of domestic abuse. It is why we have an internal improvement program, why we are listening so hard to child and adult victims and public concerns. We are intent on eliminating practice that isn't good enough. Shall I carry on reading?
Yeah, carry on,
Yeah, shall I read a bit more? Right. I'm sorry that
we reach a point where...
Yeah, shall I carry on?
Yeah, we reach... Yeah, no, we'll carry on for a bit, because then it gets to a point where she's just justifying her own existence, so we get bored at that point. So read that bit.
Right. I'm sorry that some 4 years on from the harm panel report, there are still children and adults in family court proceedings who do not receive the protection they deserve and require. Family court advisors and children's guardian work hard through the assessment and advice to court to protect many children and adults from harm every day. But for those for whom this isn't so, it is not acceptable, and we are determined to continue to improve and to strive to protect every child and adult in family proceedings. The new policy that we are publishing today is a very significant step to further improve the way together as a system we protect child and adult victims of domestic abuse. Right, there's not much said there, but yes, any comments on that?
I mean, it's a laudable objective. I mean, well, it's Cafcass's primary objective. You know, Cafcass's primary objective is to safeguard children. That's what they're there for. You know, so the objective of reinforcing their abuse practice policy is an excellent initiative. She's absolutely right that 4 years has gone on since the harm panel, which said that Cafcass were inadequate, that Cafcass had too many holes in their process, and it has taken them 4 years to sort of sort themselves out. They still have massive holes in their process. They still have huge issues, as I say, with their training in and around parental alienation and implacable hostility. They have no concept whatsoever of that. That gives me something of an issue. They are still using outdated diagnostic tools. The tool they use, and I won't bore you with the detail, but the tool that they use for whether a domestic abuse is evident in the home is a 26-year-old tool.
Oh, great, flipping!
It was developed by two Americans in 1999 and published in 2000. I'm sorry, but that's like 25 years ago. And to be fair, the world has kind of moved on since then, but they are still using that tool in order to measure domestic abuse. That gives me a worry, and that's something that I've challenged in court on a number of occasions. So the policy itself, as I said at the outset, I have no issue with, because it is a perfectly sensible policy which safeguards children. It is clearly very child focused, which is absolutely as it should be, and that's perfect to read. But with every bit of paper that you write on, whatever words you write, you present somebody else with an ulterior opportunity. And there are a number, and I'll pick them out now, but there are a number of areas of this report that just concern me. I mean, the practice itself is 6 pages long. Well, in fact, 7 pages long. In fact, yeah, the practice itself is 7 pages long. I'm certainly not proposing to read it all, because, as I say, all of us would lose the will to live. But I'll pick out some of the more interesting stuff, like that practitioners must use the domestic abuse training to analyse and assess all accounts of coercive, controlling, and any other high-risk behaviours, and the impact of these on the child and of the victim, including, and here's the interesting point, including connected children who are not the subject of proceedings. Now, what that's saying is if a father, and we'll use the father as an example, if the father has moved on during these proceedings and he's now in a new relationship and he's got 2 children in his home that are nothing to do with the proceedings, those 2 children will now be pulled into the proceedings.
Oh, really? Bloody
Those
hell.
2 children, if the father gets findings made against him, if they decide that some of these allegations are true in a fact find, and we'll come to that in a minute, then the children who are also in his care, the connected children, will also be the subject of risk assessments. He could be finding himself with Cafcass leaning on him in terms of the children he's got with mum in the proceedings, but then he could also find himself with the local social services, children's services, leaning on him in relation to the other children who are in his care.
Okay, look, if they lean on him, so let's say, look, let's say let's say these are obviously false allegations against the father, right? Yeah. When they lean on him and they speak to his partner, the partner that he's with, whose children that they're now concerned about, they will obviously surely speak to that partner and those children. And I mean, providing everything's, he's just a normal everyday guy who's found himself in a situation. As long as they say, yeah, look, he's cool, we've got no issue, great stepdad, whatever. The partner, the mother says, I have no issue with him around my children, hence, who are you, social services, but out. Will they back off? I mean, at the end of the day, because if the mother steps in and says, listen, stands her ground and says, leave my man alone, sort of thing, he's cool.
It will boil down to social services. I've had a couple of instances of this where social services have been given a referral by Cafcass to go and talk to connected children. And the 2 examples really are chalk and cheese, because in one example, they had the conversation, the mother did, the new partner did exactly what you just described. She said, I'm aware of these proceedings. I know exactly what's being said. I'm privy to them. He hasn't hidden anything from me, hasn't concealed anything from me. I'm acutely aware, but I am perfectly comfortable with where I am in my life, and I'm perfectly comfortable with his ability to be in connection with my children. And social services said, that's great. That's all the reassurance we need, and off they go.
Perfect.
The other coin, the other example that I have is they went to see a mother. The mother said, I'm aware and I know, and the social services said, we don't care. We still have concerns. Consequently, we are going to put your children under a child protection plan. And that has significant impacts on your life when social services stick you under a child protection plan, because they start breathing down your neck and contacting the school, and it can become quite embarrassing. So the whole issue of connected children, whilst there are a number of my cases currently where I absolutely want connected children to be involved because there are issues and I have concerns about their safety. There are other cases, obviously, where I'm thinking, well, the connected children just aren't relevant to this. So it's but they've got to pick a position. So their position is we'll deal with all the children. That's okay. I'm okay with that. The more concerning point within that I've just described, which is point 3 in their practice policy, if anybody wants to read the whole thing, is it says that Cafcass family officers have got to analyse and assess all accounts of coercive control. My problem is this. I don't think Cafcass know what coercive control is. The police struggle to know what coercive control is. I have been involved in half a dozen cases where we've presented coercive and controlling behaviour allegations to the police, and they have pondered it for a bit and then come back and said, no, we don't see any issue here, and then just drop the whole thing. But then outside that, when you have an off-the-record conversation with them, they are very honest and say, we actually have no idea what coercive and controlling behaviour is.
The thing is, Mr. Wright, I don't think anyone truly knows what coercive control is, because the problem is this, look, and this is the problem I find. The only people that I have known to truly suffer from coercive control are fathers, especially when you're in a relationship with these personality disorder types, because They've indirectly made it clear, I am the primary carer with the children. I control whether they'll see your parents, whether they're their grandparents, uncles and aunts on your side of family. You need to toe the line because I'm unpredictable. Hence, these fathers head down, toe the line. They don't want to upset the apple cart because they know the impact or the backlash of this will be severe because they're dealing with someone who's, say, unpredictable. They're coercive. I know a lot of fathers who will never truly openly talk at home and say what they think or express opinion because they don't want to upset their partner. Because if they don't agree or not along, there's a backlash. That's the closest I can understand to what coercive control is. But what is being presented, from what I've seen in family court and this whole arena, is if a mother, say a female or woman, a mother says it, who appears to look weaker and soft and gentle and nice sort of little lady, it's much easier to believe. And when you strip when I've sat with these people, I've looked at what is the issue. Like, you think his husband's such this monster, geezer, big ass geezer, kind of, football hooligan type, or a brother with a big ass beard and hat. And I think, okay, you've got this perception. You think, yeah, he looks like a bit of a, he looks a bit controlling. When you sit down and strip it back, they were discussing something and he just disagreed with his partner's opinion. That effectively is what being sold. And this is the problem. That is being sold as coercive control. If you disagree, if you don't nod along, and how do you, and the fact is look, Phil Kedge said it best. If you are in a relationship or marriage, you are controlled to some level. You can't do what you want. You can't go, like, for example, if you're in a relationship with someone, you can't go and sleep around. That's the bottom line. Unless you've arranged it, unless it's an arrangement with open relationship, any normal relationship, the bottom line is, I am sure most men would like to have their cake and eat it, but they can't because you've committed to someone. You're in a relationship. So does that mean you're coercively controlled? I mean, this is the problem. We're all controlled in a relationship to some level. I'm sure we'd all like to behave badly. I'm sure some of us can't be bothered to have a shower every now and then. But when you're in a relationship, you want to maintain some hygiene and standards and put your partner off. Like, do you know what I'm saying? Some people go on.
It's difficult. I say, and yeah, there's a world of issues around coercive control. But the single biggest issue is the fact that, despite the fact the Crown Prosecution Service have defined coercive control, and that their definition runs to about 8 pages. And if you've read the 8 pages, you still won't understand it at the end of it. But we still have this issue that we don't really understand it. And so asking a CAFCASS officer, we want you to assess and analyze coercive control, I don't believe that is within their capability. That is my problem. Because coercive control has a degree of subjectivity to it. There's a degree of, well, in my opinion, that's not coercive control.
Yes.
In your opinion, it is. That's the problem. It's quite vague. It's quite grey, and it's a difficult one to track. But it is going to become, and it's going to continue to become, an issue because, as I say, it's obviously now on the serious crime bill, has been for 10 years. And there are now cases coming through CPS where they're actually making prosecutions against coercive control. So
a TV actor that recently got done, the one from that afternoon show, The Repair Shop.
Yes, indeed. As I say, Blades.
That's it. He's been Jay Blades.
Jay Blades. There we go. Thank you. Yeah. So obviously Jay Blades has been in court. He was in court a couple of days ago. He's denied. He has denied that he has been coercively controlling and coercively behaving towards his ex-wife. That will now go to full trial, and we'll see where it goes. That'll be interesting because that case will be so high profile. Because he's a TV celebrity, whatever that means these days. The guy appears to make things, but anyway. But that trial will highlight the whole issue of, when it comes to trial, and I think it's probably not till next year, but that will really highlight the whole issue of coercive and controlling behaviour, because it is going to be paraded across court as to what he's been doing. Perpetual texting, gaslighting, blah 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 blah. So we'll see. But if we return, I'm just going to go right to the back page. I'm going to go right to the back page of the policy, and I'm looking at point 21 because this really does summarize. Whether you've got it on there, but this really does summarize where the potential obstacles are, the threat is. It says, in considering recommendations for family time, where there has been a report of sexual offence, practitioners must assess the child's safety and welfare, grounding this in an understanding of the offender's attitudes and behaviour and a deeper understanding of the child's experience and vulnerability. It then says, practitioners must be informed and they must test by applying the following starting points in relation to what is known. So here we go. Point number 1. If there is a report of sexual offending, such as rape, the starting point must be to consider the risk of harm to the child and the need for a fact-finding hearing and the immediate suspension of any pre-existing direct spending time arrangements. So there we go. As we said right at the very start, if somebody has gone to the police and they've raised sexual abuse, you're gonna have your contact with your children removed at that point. Automatic. It's going to happen.
God, yeah.
Problem that we have is mother, and it's invariably mother, and that's not. I'm not looking to
bash mothers,
to badmouth mothers, but unfortunately, it is invariably mothers. Mother has now been handed a weapon. All you got to do is go to the police. Point 2: if a fact finding is already scheduled, and this point worries me. If a fact finding is already scheduled, the starting point must be no direct contact with the accused parent for the children. So you go to court, the judge says, well, we need to take this to fact find. At this point, the two parents are sharing the kids, for argument's sake. One's got them Monday to Wednesday, the other one's got them Thursday to Sunday. But because a fact find has now been ordered, this policy is saying that contact now must end because there is a question mark over the one parent. That concerns me. If there is a disclosure of a sexual around point C, if there is a disclosure of a sexual offence and this has resulted in a police investigation or a charging decision, the starting point must be no direct contact until the police have concluded their investigation or the criminal process has run its course. So I have an example. I'm going to use a very live case, which happened earlier this year. A guy had been accused of, let's say it as it is, he had been accused of rape by his wife. He got arrested. He got interviewed 3 or 4 times. They charged him with the act. They put it up for trial. He waited 3.5 years for the trial because of the court system. Because the criminal system is as bad as the family court system. So he waited 3.5 years for his trial to come up. In that 3.5 years, no contact whatsoever with his children.
Yeah.
3.5 years. When he gets to trial, and the trial was earlier this year, he arrived on the day for what was scheduled to be a 3-day trial, 3-day jury trial. He walked into court with his solicitor, with obviously some concern as to whether 3 days later he's going to end up in prison. He's got no idea. CPS order a pre-trial hearing meeting, and CPS say, we've reviewed your file again, and frankly, we're not going to get a prosecution against you, so we're not going to bother.
Flipping it.
Matter is now dropped. Thanks very much, off you pop.
My God.
3.5 years. His ability, and I went to a child hearing about 2 weeks later, where we reported on this, and the judge obviously said, well, we're delighted the matter's been concluded, blah, blah, blah. And I said, that's all well and good, Judge, but the ability of this man to repair his relationship with children that he has not had any contact with at all, nothing, for 3.5 years is
done. It's done. Damage is done. I hate to say it, as sad as it is, it is
game over. So we're 6 months on from that. constituted or reconstituted contact. I think he's seen his children twice in 6 months because they don't want to see him. And it's not that they don't want to see him because they have any view about him. They don't want to see him. He's no longer in their life. He's gone.
The stranger. It's just some geezer. There's some uncle, that distant uncle that they have to go and see in a contact center, I'm presuming. And it's so awkward and uncomfortable for all parties.
Yeah.
I hate to say it, but
he's gone. And one of those children, 3.5 years ago was 14 years old. Guess what? That child is now 17 years old. Well, in fact, he's 18 in a couple of weeks.
Volatile age. It's over. Volatile age.
He's gone. His stance was very simple. When we created a little mediation session a couple of months ago with the children, with father, with some professionals in a room, and that lad came in and he said, "I don't know who you are. I don't want to know who you are.
I'll never speak to
you again." And he left.
Yeah, that's painful, man. That's tough. But look, that is a 17-year-old man, more or less. 1 more year, will be ready to vote. So he's closer than bordering a man, right?
Yeah.
Very volatile age, testosterone, up and down. Gone through these sort of years where hormones are up and down. He's just 3 years later. It's just some geezer that he once knew. It's like an old school teacher that he bumped into and said, "Well, look, I don't really want to know you. The school's over. You were a teacher back then. Yeah, I put up with you then, but I don't really see you anymore." And that's it.
Exactly, and that's dreadful. So that's one of the issues that a policy like this, and I appreciate there has to be something. There has to be some sort of framework that safeguards children, because obviously we're just assuming that the allegations are always false. In some instances, the allegations are true.
Yes.
In which case, these children should be safeguarded. Because there are some people out there who are pretty unpleasant.
Absolutely, yes.
But because we're having to, the problem with a policy like this is you have to tar everybody with the same brush. And so unfortunately the innocent and the guilty are all lobbed into the same cell. And we patiently wait until we work out which one should stay and which one should be allowed out.
You're guilty till proven innocent on this occasion, basically. That's how it is.
There you are. In the
interim
of the family court.
And in the interim, even if you are innocent, you may still lose contact with your kids. So forget that. That's irrelevant. That's the point I'm saying. It's hopeless. I mean, let's be honest.
It is.
It does sound a bit hopeless, like on many levels. I mean,
yeah, it is a difficult one. So in terms of just rounding it off, so in terms of CAFCASS's new domestic abuse practice policy, I have no issue with it as a practice policy. I think it's quite good in parts. My issue is the consequences of it. My issue is the ability it gives parties to understand how it is they can act around it.
I think the way I'd summarize this is, okay, like you said, there's nothing wrong with the policy in black. In theory, the policy is great. In practice, they have just basically, they've just come out with another sledgehammer to crack a nut. They've just come out with the option of another nuclear option. So saying this is a nuclear option to protect kids. And one party, like I said, the nuclear option is a nuclear option. In the right hands, it is there for protection. You can protect people with it, deterrent. In the wrong hands, you could do mass destruction. That's the bottom line. And unfortunately, the way the family court trajectory and the parties involved, the barristers, lawyers, legal aid, the whole game is a very conflicting environment. Emotions are running high. And another nuclear option is now there at hand on top of the other nuclear weapons available. That's the problem. So, I mean, considering this wasn't even out when I entered the system, and it felt like, with the Nonm occupation order and the fact that, that alone will stop you from seeing your child for a year and a half, 2 years, from what I've seen. This is one thing I don't understand, Mr. Rai, is when they're saying parents and children are not being protected by CAFCASS. From my experience and experience of many fathers that I speak to, mother got one day, disappeared. We know a chap, mother's got disappeared one day, moved up down your way, up north somewhere, middle of nowhere. He ain't seen the kid since. He haven't seen when his kid was born. One of his kids was pregnant. He haven't seen the kid that's been born yet. He has no way of getting hold of them, no way of seeing them. Even if he rocked up at the house, they just call the police. He's with a parent, they call the police, it's game over. You get the other fathers who have tried to make contact, like you said, Nonm occupation order. If you breach it, you end up in prison. So it's very difficult, even before this came out, for a father to have contact with his children. So why is there a need? Well, I don't understand. So where is the system letting these people down in between when I know how difficult it is to bypass even the system that's in place now before this came out? So where was the failings? I don't get it.
The single biggest failing in family court is the time lapse. We have to accept the fact that when you have two people who are in conflict, you're going to break some eggs to make an omelette. That's just how life is. So there are going to be arguments. There are going to have to be positions taken, and there are going to have to be moves taken, like moving children from one contact to another, or stopping contact, or restricting contact. That is going to happen until we understand what the facts are in a matter. The problem is the reason that we are destroying childhoods is because we are taking too long from the start of that process to the end, because the average family law matter now in the UK is 2 to 3 years. And the bit that we forget while we're going, well, it's 2 to 3 years, and we had a hearing, and and I was in a hearing the other day where the judge said, I can't believe our last hearing was January. That's right, love, and it's October. And how is that reasonable? How is that reasonable? Because the thing that we forget, and the thing that I often think that the family court forgets until I make a point of reminding them, which I try and do at every opportunity, is whilst we're all pottering about being clever and drawing on the law and drawing on case law and being clever about how it is that we understand parental alienation and we understand domestic abuse and we understand impacting on children, blah, blah, blah. The bit that we can't control, the bit that we can't stop, is the passage of time for children. And a day in my life as a 50-something-year-old bloke, a day in my life lasts 30 seconds. And it's gone. And then the next day starts, because they just roll into each other. In a children's life, every day is an absolute adventure. And we are robbing them of the adventures that they could have with one parent or the other, through the ineptitude of this system, and because this system is weighed down by mud and quad. That is what is killing childhoods. It's not really the decisions of the family court. It is the time lapse in the family court that is destroying childhoods.
No, okay, sir. Mr. Ryan, I get all that. I get what you're saying, but I'm saying let's bring it back to this CAFCASS law that is now in place. What I'm saying is, from a person and how I've seen the system, where is if one parent, and in 90% of the cases, if mother decides to get up and leave, or relationship ends, she gets up and leaves, claims any abuse, the mechanisms already existing in the system, as the molestation order, occupation order, the legal aid, women's aid shelters, and the support that they give. So these mechanisms are already there to help protect mother, right? I know, and like I said, I can't go up to my kids' school and see the kids, even though, like I said, I've got no molestation or occupation order. The chances of me going to see any of my kids is very difficult, because mother or someone just calls the police. Police, even if police said it's not breach or anything, they'll just say it's best if you leave, sort of thing. Yeah, it's very difficult to have that contact without this CAFCASS law in place. So what I'm saying is, if it was so difficult already, it is so difficult with the current mechanisms. Where is the breakdown where they're saying that we had to bring this in place because the children and adult victims of DV are not being protected? How, on what grounds, where is the evidence, or what grounds did they base that on? Because we know the existing law and how difficult it is. That's why this case is in family court, because we can't see. That's why they're backlogged, because we can't see our children. If we had access and arrangements, the family court wouldn't be logged up like this. You with me? So when they brought this out saying we're letting parents down and victims, children victims and adult victims, how's that possible, knowing the mechanisms that are already there? Why did they have to bring this out? I don't get it.
Well, this is not new. This abuse policy is not a new policy. It's not a new piece of statute on the book. It is an update of a policy that was in place. I think the last policy was something like 2016, 2018, something like that. So this is an update. So all they've done is they've grabbed the policy that was in place last Monday,
polished it up
before they released this, and they've reworked it, and they've tweaked it, and a lot of it is the same, to be perfectly honest. They've reworked it and they've retweaked it, and some of the amendments that they've made I find quite positive, like the fact that CAFCASS can no longer essentially prejudge a matter themselves and tell the judge, oh, by the way, I've sorted this out, mate. He did it. You know, so they've removed that power from them. So I'm comfortable with the fact that, you know, that we have to update policy, and that's what this is. It's nothing new. It's an update of a policy. It's got some positives in it. The only reason that it's a concern right now, as I say, because it isn't new. It was here on Wednesday. It was just in a slightly different wording. It's here now in its fresh wording. Is what it's done is, by virtue of the fact that they've dropped it out in the marketplace and the fact that activist groups are picking it up, we are providing free advertising for the recipe to be successful in family court and have your children kept away from dad, in the instance of your example. That's all we're doing. That's all we're doing. There's nothing new about this. It's an update. We shouldn't be panicking about it. All it's doing is reminding one party what the rest of it is.
Okay, that answers my question, and this is the point. It was always there. It's already there. They just put it back to it was lost in the back pages. They've just put it to the front pages because, like I said, I've not, you know, let's say, like, you know, there's been no evidence to prove, say, even the certain basic domestic allegations, say that, you know, put against me, and I know how difficult to see your kids and bypass this. So what they've done is, you're saying, just so all watching are clear, there's nothing to panic about. This is nothing new. This was just in the back pages. Just put it to the front, put it out there, just giving it more publicity. But the only thing it does change is CAFCASS cannot base a determination of whether they think you're innocent or guilty. They just go by present what each party has presented. They cannot take a side in that. So that's a positive. The negative is that if there is allegations of sexual abuse, that sort of nature, ultimately that will be used as a nuclear option to remove one parent completely out of the loop until the courts decide further. Even if you have contact or interim contact, anything like that, they will just shut any contact down. So that can be used, unfortunately, as a nuclear option to completely cut one parent out, which in theory, before Wednesday, they could have used that anyway, couldn't they? Because like I said, it was always there.
It wasn't as black and white. It wasn't as black and white as it is now.
Okay, so it's just a lot more in clear black and white now, that if you press this button, you get this outcome, basically. Yeah, nuclear option. Done. Okay, so that's the negative, and unfortunately we were already facing this type of issues anyway. This is just giving them more power, unfortunately, giving one parent more power. And beyond that, I mean, that's sort of really, what was it? And the last thing you said, that sort of sums up what it is, basically. Yeah, I summed it up.
Where we are. Basically, that's where we are. You know, I appreciate that people are reacting to it, because it's just presented itself, you know, in the last couple of days. It doesn't tell us anything that we probably didn't know already, apart from, as I say, a couple of little minor points, like that, you know, CAFCASS have had their power to be the judge removed, and I'm keen on that. I'm happy with that.
Okay, so look, let's take that as a positive. Now, obviously, this was meant to be a 15-minute video, Dan, but somehow you managed to drag out 52 minutes. So, look, any closing statements, anything you want to tell the people out there in the system?
I mean, there's nothing particularly exciting happening in the system. As I said, somewhere in the middle of all of this, you know, this is just an update of the policy. It's quite positive. I appreciate the downside. The downside was always there. There are a number of other systems, processes, protocols within CAFCASS that desperately need updating. And the biggest issue for me is that this policy. Nowhere does it reference parental alienation. That, for me, is a huge oversight, and that will continue to be a major concern for me.
Yeah, no, fair enough. Like I said, but those concerns are always there. Coercive control, parental alienation, no one really knows what it is. Of course, you know, CAFCASS's position to recognise it, or qualification to even recognise it or deal with it. So, look, those issues were always there. Let's take the positive that they can no longer judge you. Let's just stick with that. Beyond that, everything else was as bad as it always was. I think that's a positive way of looking at it. It's still as bad as it was. Don't worry about that.
There we go.
Right, Mr. Ryan, this has gone on too long. Thank you for clarifying this. And just for the viewers, as things change and progress in the system, we will try and bring updates to law and CAFCASS. And if you've got any information around this, we will continue to try and get the information out there, to get it to you, those who are fighting their cases, trying to see their children. Look, keep your chins up, stay positive, keep going. Any closing statements, Mr. Ryan?
That's it. Look after yourselves. Do what we do, folks. Do what we do.
Good stuff. Guys, see you on the next one. Thank you for watching Disqualified Dads. Like, subscribe, follow, and share.